years in court. That was an article that we handed out many years ago. That you can get to the as you registered that you are stuck. Today, we will be providing information to you, not legal advice, but information to you. Today to have attorney Rosalie Ballantyne on the island of St. Thomas. Attorney Ballantyne will speak about the steps that you need to get to where you need to go to resolve your issues. We also have on the island of St. Croix, Attorney Scott McShane. And Attorney McShane will speak on the probate issues and trying to deal with that probate issue that you may have. On the island of St. Thomas, we also have Attorney Anna Paiwanski. And Attorney Paiwanski will speak on trusts. So we have a good variety of topics that should touch you in one way or the other. I hope everybody has gotten their food and has settled in. I'd like to introduce my team members so that you know very quickly. On the island of St. Thomas, we have the Assistant CEO, Mr. Dwayne Benjamin, and he's in the back of the room in St. Croix, in St. Croix. We also have sitting next to him, Attorney Tracy Bola. These are from the Economic Development Authority. Handing out paperwork in yellow to my left is Director of Marketing, Selena Morris. Selena is responsible for getting the word out. In the back of the room at the registration desk is Managing Director Margarita Benjamin. And she handles Economic Development Commission, the EDC. Also in the back of the room, I have just lost thought, is Shelley Gardner, Human Resources person on the island of St. Croix. And the person responsible in the Enterprise Zone Commission for bringing this program this year is Mr. Wayne Scott Jr. On the island of St. Thomas, I have, I believe, Mr. Raheem Smith, Enterprise Zone Specialist on the island of St. Thomas, responsible for this program on the island of St. Thomas today. He's accompanied by Ms. Shayla Anthony. Ms. Shayla Anthony is an Enterprise Zone Compliance and Grants Officer. Is there anybody else in St. Thomas that I'm not seeing? You need to come to the front so I can see you. Well, okay. Oh, and we have Ms. Monique Samuel, Managing Director of the Lending Division, Economic Development Bank on the island of St. Thomas, and she is in charge, in the island of St. Croix, territory-wide, and she's in charge of the VI Slice program. So don't leave this room unless you get to her in case you need to have questions, have answers, needing answers for VI Slice. Okay, we're getting ready to start. They're in class in another classroom. Okay, so let us begin. We would like to bring to the stage Attorney Rosalie Simmons Ballantyne. She is going to speak on various topics, but I call it estate planning help. And so, Attorney Ballantyne. Okay, we need to see St. Thomas. That's St. Croix. No, that's two St. Croix.
Recording in progress.
Somebody say got it? Okay. So we can't hear you yet, Attorney Ballantyne. Somebody has to hit the got it in order for us to hear you.
Okay, you can hear me now, because I can hear me. Okay. Well, good evening to you all, and thank you for your patience, and thank you for hanging.
Hold on one second. Attorney Ballantyne, could you hold on one second? Could somebody hit the got it on their screen, please? In St. Thomas? Or in St. Croix? Awesome. Attorney Ballantyne, thank you.
Technology is not always your friend. So I want to thank the EDA and specifically the Enterprise Zone Commission staff for having this conference and for inviting me to be a part of it and presenting this information to our community. I was not expecting to be the first batter up, but I will start off and some very competent people will follow me and bring it all home. So those of you who are baseball fans, how'd I do? All right. So what are we talking about when we talk about estate planning? Some may think that it requires that you have plenty of assets. But basically what we're talking about is how your assets, whatever and how much they are, how they will be distributed after you die. And whether you want to accept it or not, we're all going to die. So we can prepare for that eventuality or have distribution of our assets done by operation of law, in which case it might not be done the way you want it done. Or worse, you may have a situation where your assets just sit. Nobody does anything, nobody takes responsibility, and your assets end up looking like some of these abandoned buildings we see all over the place. So it's really important that you plan for what it is you want to do. Now, there are other aspects of estate planning that we're not going to be focusing on tonight. But I did want to mention them for you because we want you to have a holistic view of what it is you need to be thinking about as you plan for what you want to have to happen in the end. So there are other things that include the durable power of attorney, which allows someone to take care of your business and financial needs. There are healthcare directives where you can make known your desires or preferences for your care in the event that you're no longer able to make those decisions for yourself. You can make provisions for long-term or disability care and so forth. So when you're thinking about your estate plan, you ought to be thinking about all of these things as well. Now, for our purposes this evening, we are going to be mainly focusing on ways for asset transfer. There are various mechanisms through which you can plan for the transfer of your assets. Wills and trusts are the most commonly thought of. But we can transfer certain assets by insurance policies, bank accounts, and deeds. One of the mechanisms that we find particularly useful at times is the transfer on death deed. And that's a mechanism that will allow you to transfer a piece of property without having to put it in a will or go to probate or anything like that. Or you may want to do so, transfer your assets through a corporate structure. You may have a business or an enterprise that you want to have continue. And so you may want to establish maybe a family corporation or some other kind of corporate structure that allow your asset to continue. The popular narrative most of the past few years has been to convince everyone that they need a trust. But which mechanism you use should depend on your particular circumstances and how you would most clearly and efficiently accomplish your intentions. The attorney you choose, and I would not suggest that you try to do this by yourself, the attorney you choose should be willing and able to provide you with information on the various mechanisms and assist you in determining which one or ones is best for you. I personally would be very skeptical of someone who did not take the time to educate me on all of the different things that I should consider in determining how to get rid of my assets. The best way for the attorney to assist you is for you to be prepared when you meet. Have your deeds. Have the adjudication if you got the property because someone passed and left it for you, or any documents that show the ownership of your real property. What insurance policies do you have? And do you have designated beneficiaries? Do you already have a will? If so, what changes are you considering? Are your bank accounts jointly held? Do you have a business or some enterprise that you want continued? Who are the persons to whom you wish to leave the assets? Who will be the executor of your will or succeeding trustee of your trust? Is this someone who is trustworthy and will see that your purposes and intentions are carried through? Do you have minor children or someone with special needs that may need a guardian? These are some of the basic questions and considerations that you should be mulling over in anticipation of your meeting with your attorney. And you should bring to your meeting all the documents you have in support of the questions, in support of the answers to those questions. I've had clients who say that they brought everything they found, even if it's not necessary. But that's preferable to not having anything at all. So when you start thinking about, I need to start planning what to do with my assets, what's going to happen in the end, who do I want to take care of my children, whatever you have, start putting those things together. Start looking at them now. You may find you may have a lot more than you think, and you may also be missing some very important things that you can start trying to put together now. So it's important that you not just think about one aspect of things, like what am I going to do with my house, but think about all of it holistically in terms of your family, what you want to see happen. You know, a lot of us, I've had a lot of people want to leave everything to all my children. And you know, that sounds really, really good. It sounds really good because I don't want to make fortunately for me, I only have one, but I don't want to make choices, right? I don't want to have to say John over Mary over Jane. But, you know, let me tell you, it doesn't always work out in the best for all of your children. You know, so again, those are discussions you want to have. And be honest, right? I know, you all know if you have more than one child, you know which ones are most reliable, which ones you can really count on to do what you want done. So, you know, those are conversations you want to have with your attorney so that they can assist you in determining what might be the best way for you to make sure that things are going to be done and everyone is going to be able to get, but the person that's most reliable will be the one that will assist in getting that done. So all of these are honest conversations. Don't be shy about having an honest conversation with someone that you are asking to assist you, especially in determining, because once you're gone, it's left, right? So you want to the best you can, because I always also tell people that you cannot legislate beyond the grave. You know, if you're dead, you can't control anything that's going on up here, you know? But you want to do the best you can before, in terms of leaving things in a state and a condition that everyone knows what it is you want done at the end. So once you and your attorney have decided what are the best mechanisms or the best mechanism for you in terms of accomplishing what it is you want accomplished, you still need to stay engaged. Because, as I just said, this is the last word that you have in terms of what you want to have happen to your assets, or who you want to take care of your child or children, or your parents, or whatever, or how you want your business to continue. So you need to make sure that you provide everything that you can, that you ask questions. Don't be reluctant to ask questions, okay? So that you ask all of the questions you can, that you look at the documents that are being prepared, because these are your documents, not the attorney's documents. The attorney's preparing them. They are your documents when it's all done. And you want to be sure that you understand, and that the people that are going to be taking care of this when you're done, that they understand what it is supposed to happen when you pass. No guarantee that everybody's going to follow on, and no guarantee everybody's going to agree, but this is what you want, and that's what's supposed to be your driving factor. So make sure that your final product reflects what you want to have happen to your assets and how you want your heirs to be taken care of. Now, my role up here today is to just give you a general overview, right? There are going to be others giving you specifics about other things, but I'm just giving you a general overview, and when I'm done, you can ask me any questions you have about anything that you might want to know a little bit more about. But I hope that this sets the stage for you to start thinking, when you hear about the other specifics from the other people, that you're now starting to get some questions mulling over in your mind that you might be able prepared to ask them those questions. Everyone should have a plan. No one has nothing, right? You have something that you want, almost all of us, and the reason that you are here is because there is something that you want to be, that you are thinking about in terms of how am I going to prepare for my children? How am I going to leave my assets? What's going to happen when I die? To all the things that I've worked so hard in this life to accomplish and can't take with me. Who's going to take care of them when I'm gone, right? Isn't that what I mean? That's where we are. That's basically where we are. So we all need to make sure that you have a plan. So when you get this information, don't just have it. Do something with it. Okay, whatever it is, do something with it. So before I take your questions, I just want to speak on one particular mechanism that I am particularly partial to. I think that everyone should have a will. I'm not saying that a will is the only thing that you should have, but I think everyone should have a will. If you have a trust, you should have a will. If you transfer your real property by transfer, my house is in the trust. You got to do a deed that transfers that property from you to your trust. So I always say, have your backup plan. And part of that backup plan is you have your will. And your will, it could be as simple, it could be as complex. It could be as simple as saying, anything that I did not put in my trust, I want to be distributed this way. End of story. That'll at least make sure that if something went amiss in the creation of your trust, or something happened, or you got something later on that you never put in there, it at least will make sure that an asset, every asset you have, is being distributed to your beneficiaries the way you want it distributed. So, that's my spiel on estate planning. Questions? Ah, fantastic. Yes.
In your experience, are there assets that you find often go overlooked when families are planning their estates for the time of their death? I know most people think about like real property, but are there other particular assets that commonly go overlooked, you find in your experience, that we should be aware of?
Well, I read something recently. I don't know if this is necessarily something you'll put in your trust or whatever, but in terms of accumulating your assets, I read something recently that Corningware and Pyrex dishes, don't throw them out because they can be very valuable nowadays. And did you all read that? Did anybody else read that? No, that Pyrex dish, the ones, especially the white ones with the little blue trim around the side that your mother and your grandmother had, if you still have them in good condition, it ain't gonna be $1 million. No, I'm not saying that, but that $20 Pyrex dish may be a few $100. So I'm saying that everything you have could have a value. It's for you to really sometimes look at it, assess. A lot of us sometimes have, I've seen situations where people, I have not had the experience, but I've seen where people, they pick up a picture or they pick up an item at a yard sale or something like that, and the next thing they know, it's got some value. So you want to, anything you have could have a value. It may have a sentimental value, if not a financial value. So especially in that case, you want to make sure, that whoever you want to have those things, that those are accumulated and somebody knows that you want.
From Zoom.
Oh dear.
If you put your house in the name of the trust on the deed, is that the best way to transfer large property?
Okay, I'm not sure I understand the question. If you have a trust, then the way that you will transfer, your property would have to be in the name of the trust. So you would make a deed. There would be a deed from you or whomever owns the property to the trust, and now the property is an asset of the trust. So then, however, whatever the terms of the trust are in terms of what you want to happen, how the property is to be used, and whatever, all of that will be delineated in the trust. But I'm sure Anna will speak to that some more when she speaks. But but the property would have to be in the trust.
So I think that they might have been asking the question with regard to, I own a piece of property and I know I'm giving it to child number 3.
Mm-hmm.
So I'll just put their name on the deed itself.
Again, Well, that sounds like, if I'm understanding it, that might be one of those times when you may want to consider using a transfer on death deed, because what that does, you put the property, the deed, there's a deed where the property goes into that person's name, but that person has no interest, has no ownership, has no claim against that property until you die. But once you die and they know that they file your death certificate with the recorder of deeds, it is alongside there with that deed that has already been recorded, and it's theirs.
Okay. Are there any questions from St. Croix? We have a couple more questions there, but I want to get to the next attorney and then we'll come back to questions. Okay? So we're getting for your work. You have somebody
Recording
in
in
here
progress.
owns in one of our rooms, whether that be online or in any of the rooms in the territory that's listening to this today. But you can take charge and be excused out of that situation if you take steps, right? Many of these properties are appearing to be derelict and abandoned because they're owned by multiple people over multiple generations. As a historian, I study these families, and sometimes we go back to enslavement where it's been handed. They got their freedom and they bought property immediately. But then they're still there in limbo. Attorney Scott McShane will speak about probate. So Attorney McShane, please rise, come to the podium.
Good evening once again, everybody. Yeah, I'm going to need that Coke. I have a little bit of a cold. Thank you. Once again, I would like to thank the Enterprise Zone Committee today and Nadine Marchena for putting on this presentation. I think it's a tremendous credit to her that this program has grown from 90 to over 500 attendees over the course of time, especially with COVID in the intermission. But I also think it's a testament to the community and the community's needs and the concerns that the community has, because this many people showing up shows me that there really is a lot of concern about how best to deal with these issues, and it probably comes, unfortunately, from their negative experiences. So I am here today to talk about dealing with the challenges of probate, and it's something of an irony because I spent my morning today in a probate that's 14 years old, and I brought 5 witnesses. I had subpoenaed witnesses take off of work. I had witnesses come down from Florida, and the hearing was continued for 3 more months. So the process can be long and it can be daunting. And I think the estate planning terms that Attorney Ballantyne talked about and the estate planning terms that Attorney Pawanski will talk about are basically ways that if you work through them will help you and your family and your beneficiaries to avoid this 14-year process. So it takes some thought. It's not an easy thing, but it is an important thing. So for me, in talking about probate is really talking about when the estate planning is over, when sort of the rubber meets the road, when it's time to not plan anymore, but to deal with the estate that you've been dealt. And that's the estate that you've been dealt, whether you're a trustee under a trust or whether you're an executor if there's a will, or whether you're administrator if there is no will. And one thing I want to make clear, I'm not going to talk too much about estate planning, but a lot of people seem to believe that if you have a will, you avoid probate. No. If you have a will, you go directly to probate. The only difference between having a will and not having a will is that you get to decide who gets your assets versus the court deciding who gets your assets. So a will is a good thing, but it is not an estate planning tool that avoids probate. It's an estate planning tool that takes you directly to probate. So the process of probate, in sort of the view from 50,000 feet, is actually a fairly simple process. The executor, if there's a will, or the administrator, if there's not a will, files a petition for probate, and when the petition gets granted, their job is simply to marshal all the decedent's assets, that is, identify all those assets, pay all the decedent's liabilities, that is, pay their last WAPA bill, pay their last Netflix bill, pay their last car payment, and then the last thing you do is you distribute the assets to the beneficiaries if there's a will, or to the heirs if the person dies without a will. And so it seems pretty simple, pretty straightforward. And so why are we spending 14 years or 27 years in the case of Nadine's case? And the answer really is unfortunately the devil is in the details. And so when I'm going to get a little bit into those details. When the executor or administrator comes into the estate, they have to marshal the assets, which is identify the assets. And it sounds easy, but it's not. It's actually very difficult. You have to find, the house that your parents owned or the decedent owns, but what about that bank account they opened 30 years ago at a bank that's now closed? What about insurance policies? What about, there's life insurance policies, there's annuities, 401ks, IRAs, pensions. There's a lot of assets out there and very difficult. So I would say that communication is one of the most important things in both estate planning and in the probate process. It's very helpful, whether you have a will or whether you have a trust, that you talk to your successor trustee in the case of a trust, or your proposed executor in the case of a will, to help them to find where those assets are. Provide them with a list of your attorneys, your accountants, your financial advisors, your bankers, your CPAs, and preferably have a conversation with them so that when you do the will and you talk to your proposed executor, they know where to find these assets. And it's not just, everything's up in the box in the corner of the closet, because that's what unfortunately happens a lot. And then it takes a long time to sort through boxes of papers and to sort through tons of documents in order to find where the bank accounts are, where the assets are, whose name they're in, etc. So the devil truly is in the details, and I think some of the ways to solve those devilish details is simply through communication. As Attorney Ballantyne said, we're all terminal, we're all going to die, so we shouldn't be ashamed about talking about death or imminent death or what's going to happen after we pass. Estate planning is really, in my mind, a fancy term for family planning. It's really planning a smooth transition of the material wealth that you possess to the next generation. And trying to communicate how you're going to do that to the next generation is going to be very helpful in making that transition smoothly and in making the probate go faster. Paying expenses, again, sometimes it's hard to figure out what the expenses are of the estate, and sometimes you're monitoring the mail for years before you find, bills coming in from places that are unexpected, or, old child support liens coming in from 30 years ago, and now they want to go after assets. So it's just devils in the details. So we talk about marshaling assets, we talk about paying the expenses, and last we talk about distributing the assets. And of course, that's the fun part, right? At the very end, you get to take all the assets that you found and pay all the bills, and now you get to give everything to everyone that gets everything they're supposed to get. And that's when sometimes the fighting starts, especially when people aren't getting what they think they should get or what they think they deserve. Again, as part of more estate planning, it's good to have, as part of the estate planning, not only drafting the documents that Attorney Ballantyne has talked about, but communicating with your executor and communicating with the beneficiaries what to expect and why they should expect what they're getting so that no one is surprised. Again, these are conversations that can be handled in a mature and in an adult way, and it just helps to set the tone, if you will, and set people's expectations so no one is disappointed. If people are disappointed, they're entitled to what's called a will challenge. And in a will challenge, they'll basically raise an issue that, hey, that will that's being presented and the distribution that's being proposed is a false will, that it was coerced by one of the beneficiaries that's getting more or something like that. And I mean, this sounds like something out of a soap opera, and oftentimes it does sound like it's out of a soap opera, but it besides being somewhat funny, in the real world, it can tear families apart, and it's not really a laughing matter at all. So, again, it seems to go down, in my mind, to to communication. Some of the other details that an executor has to take on once the estate goes into probate, the whole process is monitored by a judge over the course of time. Notices have to be published in the newspaper to creditors. A period of time has to go by before creditors who may become aware of someone's passing to file creditors' claims. That's a 1 month process, and then there's 4 weeks for creditors to file claims. So there's automatically built in like a 6 week time lag, 6 month time lag for handling creditors' claims. During the course of the administration, tax returns may become due, so you may need to hire CPAs or accountants to file the decedent's/tax return, to file any subsequent returns. If they have a business, you may need to hire an accountant to deal with business tax returns, gross receipts tax returns, etc. And then, of course, as part of the communication process from the executor to the heirs that's monitored by the judge, there's a quarterly accounting requirement. So it requires, quite frankly, an executor to have a fair amount of math skills, because every 3 months, the executor, and sometimes the executors think, hey, I'm just jumping in and giving away the assets and doing a good deed for mom after she passed. Well, there's an accounting component, and that can be overwhelming for people that are challenged by numbers. And but it's something that you should be aware of. Every quarter, you're required to file with the court and circulate to the heirs or the beneficiaries a quarterly accounting, a profit and loss statement. So if there was a business involved, if there's a rental apartment involved, if there's a rental business involved, you got to report your income and your expense and your net income. And then, of course, there's also a quarterly requirement to file a balance sheet, which is your income and sort of your assets minus your liabilities. So the devil is in the details, and it's a fair amount of work. But again, with good estate planning and with good communications, these are things that can be done, and you just need to be aware of them. I'm going to go over, very generally, some of the things, some of the problems that I've experienced in the course of handling probate matters over the last 25 years. They don't all last 27 years, or they don't all last 14 years like the one I had today. But there are certain things that make them take longer and certain things that make them go faster. The first thing I would suggest to all of you as citizens of the Virgin Islands, if you have friends that are senators, if you talk to senators, is just to consider providing more funding to the probate courts. I think a lot of times they don't get enough funding, and they're basically overworked, especially when the cases get complex. I think on St. Croix here they have 1 probate clerk for 2 judges, and there's a lot of work to do, especially when the probates get complex. Another thing I would recommend to all of you, if you have someone in your family passing away and they do want you, or you are eligible to be an executor or an administrator, file it quickly. Don't wait. Most of the problems that I see crop up in probate that results in them taking so long has to do with delay. A lot of times someone passes, there's a grieving process, and then things go back to the status quo. And, the kids are living in the other houses on the property. Maybe one of them moves into the family home, and life goes on until something happens that changes the status quo. Maybe now someone wants to sell a piece or carve a piece out, and now 10 or 12 years after someone's passed, they try to probate the estate. And then when that happens, you find that just a lot of things have changed. One of the things that the executor has to do, or the administrator, when they first are granted the right to execute the estate, is that they have to notify all of the heirs. And heirs means more than beneficiaries. Heirs means anyone entitled at law, even if they're not a beneficiary. So, even if there's one beneficiary under the will, if there's 14 kids, you got to find all 14 kids. And if 14 years have gone by since the decedent passed, trying to track down those kids, they've gone off to the States, they've gone off to Europe, they've gone down island, and it's really hard to find them. And if you can't find them, the court's not going to move the case. And so it creates a lot of delay. The other thing that the timing affects is the number of heirs. So if 14 years pass, there's a good chance that some of those children of the decedent have had children, and there's a good chance that some of those children have had children, and sometimes those children have had children, and suddenly the number of heirs you have goes from 6 to 60. And twice during the course of an administration or probate, you have to notify every single heir, once before the executor or administrator is appointed and once before the final accounting. And so if you got 60 heirs and you can't find half of them, and now you got to try to find them, track them down, hire private investigators, it is an absolute nightmare, and it slows a lot of things down. And a lot of that can be avoided simply by addressing probate promptly. So that's one of the problems that all of us here as citizens in this community can address simply by being more proactive after someone has passed. And it's tough because when you lose a family member, the funnest thing to do is not to jump into court and have to hash up a lot of these issues. But it's the right thing to do. Other than that, I think I've stressed communication, and communication is so important. Communication is important not only for the executor, not only for the decedent. The decedent should be communicating during the course of developing their estate plan. They should be communicating what they want to have happen with their assets to their beneficiaries, as part of their estate plan. Now the estate plan's over, the person has passed, and when the executor is appointed or the administrator is appointed, it's important for them to be communicating, to the heirs and the beneficiaries. And I hate to keep saying executors and administrators, heirs and beneficiaries, but that's the reality. A probate estate with a will has an executor and beneficiaries, and a probate estate without a will has an administrator and heirs. So I'm not using them interchangeably. They're unfortunately related to how a person passes. But the communication, again, is key. I can assure you that when you're appointed or someone is appointed as executor or administrator, if after they're appointed, there's no further communication from them to the beneficiaries for a period of time. There's no accountings that are filed. There's nothing that's being done in court. There's no discussions. There's no group meetings. That at some point, those heirs and beneficiaries will start to think you're stealing. And when they start to think you're stealing, then they're going to hire attorneys. They're going to object to your executorship. They're going to demand accountings. And the motion practice and the motions start to fly. And then the court has to take time to go through those, to have hearings, and ultimately to make rulings. And until those rulings are made, a lot of times nothing further can be done in progressing the administration of the estate, from the marshaling of the assets to the paying of the debts to the administration. So you've just created a huge, it's like a self-inflicted wound. You've created a huge hurdle for yourself, and now you have to overcome. And lastly, as part of that communication, I think it's important for executors and quite frankly for beneficiaries and beneficiaries and heirs to think about compromise. These assets are generally not passing to strangers. They're passing, from family members down to other family members, usually in the next generation. We're talking about generational wealth going from parents to children. And as part of that process, parents make the best decisions that they can make. It's not always the right decision, and sometimes over time situations change and it may not be the best decision at the time that the decedent passes, but it's the decision they made. It's the best decision they made at the time they made it. And if the beneficiaries and the heirs are unhappy with that decision, the family should get together and try to work on a compromise. And I think it's up to the executors and the administrators as the leaders, if you will, the executive that's governing this probate process to try to facilitate that so that when you get to the finish line, when you get to the point where you're finally trying to distribute those assets to the beneficiaries or those assets to the heirs, that you don't get another flurry of motion practice, another flurry of objections, a will challenge. And, again, it stops the court in its tracks. They've got to conduct hearings. They've got to make rulings. And ultimately, no one in the family gets the assets until there's a ruling. So the whole process slows down. So that's really kind of it for me. I went generally through the process, if you will, of probate in a very sort of large overview, and then I tried to go through in some more granular detail some of the issues that I see cropping up during the course of administration. And then lastly, I tried to, I think, tell you a little bit about some of the problems I've seen during the course of my lawyering career in helping to facilitate the administration of these estates. So at this point, I would, I guess, see if anyone has any questions for me.
We have 2 questions from online before we go to St. Croix and then St. Thomas.
Fire away.
Who pays the cost of probate? Is it shared among the parties who are probating the will? Who pays the cost of probate? Is it shared among the parties who are probating the will?
The probate estate pays the expense of the probate, and so ultimately that expense comes out of the assets of the estate, and that is then shared to all the heirs or the beneficiaries. So let's say the cost of probate is $10,000 and there's $50,000 in assets in the estate. The final adjudication will basically say there's $50,000 of assets, there's 5 kids, each of them is going to get $10,000, but then we're going to subtract $2,000 from each of them to pay the costs of the probate, so they each get $8,000.
And which process prevents probate?
Which process prevents probate? So there are many mechanisms to prevent probate. Having a trust and putting all your assets in the trust will help you to avoid probate. And now we have a lot of really wonderful mechanisms. In 2019, the Virgin Islands Senate passed a Transfer on Death Act. Rosalie Simmons mentioned it. And you can now transfer a deed from yourself or your spouse back to yourself with a transfer on death to your beneficiaries. And then your primary asset, your home, and also secondary assets like cars, can be transferred at death by the mere recordation of a death certificate. So those 2 prime assets can transfer outside of probate and outside of a trust. Very powerful tool.
Okay, St. Croix, if there's any questions? Come.
Good evening.
Hi, good evening.
Not so much of a question, just more of a, I guess, follow-up to you answering that the estate pays for the probate. However, it's really like an upfront. That comes out at end, but if you don't have the money upfront to afford those fees going forward, it really doesn't get resolved, correct?
You are correct. So just to clarify, I mean, over the course of the entire probate, the expenses come out of the net assets. But if the estate is not liquid, then unfortunately someone's got to come up with the money, and usually it's the executor. So unfortunately, family members or the executor are going to have to pay upfront for the costs and attorney's fees. And then they file what's called a creditor's claim for the costs and attorney's fees that have been incurred. The court will generally grant that, and then they'll get reimbursed for any costs that they fronted, if you will. But that is another challenge, and a real challenge. Unfortunately, I would say probate is not cheap. I would say we've heard the horror stories on 20 or 14 years, but I think realistically, on a simple estate plan that's well prepared without a whole lot of motion practice, you're looking at 18 months to 2 years here on St. Croix. I've heard it's longer on St. Thomas, but I'll let them discuss that. So there are costs, and if the estate is not liquid, those costs unfortunately have to be borne by one of the more liquid heirs or beneficiaries to be recouped towards the end. And I guess that, to answer your question a little more, that could be one reason for potential delay in filing the probate.
Scott, how can we improve probate in the Virgin Islands? It sounds really messy in general. Are there other laws, other ways of doing this out there that we just haven't incorporated? Our Senate is trying to address some of these issues, as Nadine suggested. I think, especially on cleaning up some of the older and some of the messier estates, it's the court would benefit, I think, from a little more manpower. Unfortunately, every time a motion is filed, one side files a motion, the other side files a response, and then the initial movement files a reply. So you got 3 documents. Sometimes those documents are 15 or 20 pages each, so you're looking at 60 or 70 pages of documents. Sometimes there's attachments of hundreds of pages, and the court needs to get through those in order to make rulings. And if there's 20 or 30 other cases in front of them, it just takes time. I think manpower helps. Certainly there's a lot of very standardized estate laws that exist throughout the states. Those can be looked at and incorporated here. I think just seeing this many people here in person on St. Croix, as well as those that are online, I think should make the Senate and should make the government take notice that this is an issue of real concern for all of us, because if we're stuck in probate and nothing gets moved, it's not just a problem for your family or your family, it's a problem for our community. I don't know if that answers the question, but those are my thoughts.
I'd like to turn to the island of St. Thomas now, and there are some questions there. St. Thomas.
The question is, what mode of transfer?
Well, I thought there were questions there.
Louder? What mode of transfer is necessary in this situation? Grandmother passed, 6 children, final adjudication was filed. Now, 4 children have passed. You have 1 heir, 1 incapacitated of the 2. So what mode of transfer can you do at this stage?
We didn't hear your whole question. Could you please ask it again?
Grandmother passed, 6 children. Final adjudication was filed. Now, of the 6 children, 4 have passed. 2 are alive. 1 is incapacitated. The other is good. But what form of transfer can be done for the grandchildren at this stage?
Was there a will, or was there
no will, no
did
trust.
the person die in test?
No will or trust.
All right, so the person died intestate, so the law of descent and distribution would apply. And did the children that passed pass before the grandmother or after the grandmother?
After the grandmother. So the real
All
question
right, so
is
then
the real question is the incapacitated heir that's alive, along with the other that's good. Should they? How do they get it on to the grandchildren at this stage?
So I'm going to try to answer the whole thing. So there was 6 grands. 1 is alive, 1 is incapacitated, and the other 4 have passed.
No. Grandmother, 6 children. Final adjudication was filed for the 6 children. Now 4 have passed. You have 1 incapacitated after the final adjudication, and 1 is good. So you've got 2 children, 1 incapacitated, and 1 good heir. What do you do?
So the shares that go.
Go ahead.
So the shares that go to the 4 deceased children would go to their estates. So unfortunately, you can't distribute anything until those estates are opened, either by yourself or by someone else. With regard to the incapacitated person, perhaps a guardian needs to be appointed, or perhaps there's a power of attorney, and the assets can be distributed to their power of attorney or to their guardian. And then to the remaining, they would simply get their share.
I want to remind everyone that this conference provides information and not legal advice.
And I guess I was stating that more as a hypothetical than as a, no names were mentioned, so I was addressing it as a hypothetical.
Yes, I understand, and that's a situation for many of us, so I'm allowing that question, but I just want to make sure that we are all clear.
And that is not an uncommon fact pattern.
Right. So information, not legal advice, okay? All right, thank you so much. We have time for one more question from St. Thomas.
All right.
Hi.
No.
Could you, hello? Can you hear?
Yes. Yes, we can hear you.
Could you share any advice on ways one can prep or prepare to be an executor?
I guess I would suggest that you bone up on your communication skills. You develop, you keep your relations with your family close, and you bone up on your accounting. It's the one skill that most people don't have, and it's the one skill that we really need every 3 months. And if you don't file them, the court will get very upset.
So,
most of the time, I would say that executors are quite often guided through the process, either by an attorney. There's also self-help books. I think there's a Executors for Dummies book out there, one of those yellow books. I have one in my library. I share it with my clients. I've looked at it a few times too.
so we'd like to thank Attorney McShane for now. He will be back up when we do our last round of questions.
Thank you, thank you.
So a couple things before we get to our last presenter. I wanted to make sure that I acknowledge staff members on the island of St. Thomas. In the room would be Mr. Raheem Smith, Enterprise Zone Specialist, Shayla Anthony, Compliance and Program Manager. We have 2 marketing people, Kyle Thomas and Simile George, in the room, as well as an accountant from the Economic Development Authority, Ms. Jana Kami. So I just wanted to acknowledge them. They're on the island of St. Thomas, making sure that things go smoothly. So thank you. I also would like to acknowledge someone who has been at the forefront. The Enterprise Zone does a lot of work within the community. And we have a grant that we have received to assist people in a pilot program to do their estate planning. So once we're finished with this pilot program, we will have the ability to publish to the general public ideas of how to go forward in dealing with your estate planning issue. Always calling my office and always in the forefront of looking forward and trying to assist the people of St. Croix, especially the historic town and the Enterprise Zone of Christiansted. We would like to recognize Ms. Vivian Flood today as someone who is always pushing us to do more and do better for the people of St. Croix and the Virgin Islands.
I had to say something. I was not expecting this at all. I do talk to her frequently, but I am humbled because the telephone calls are for moments like these. And asking the difficult questions, and there are not many of them. So, but we appreciate that anything we can do and anything I can do, I will continue to do, because this is all of us island home.
Thank you, Ms. Flood. Okay, we have one other speaker before we ask questions of the general group. Anna Paiwanski. Trusts. And I titled her speech, which this is not how she titled it, but I titled it Speaking from the Grave. I remember an attorney out of St. Croix a very long time ago saying that if you want your stuff done the way you want it done once you've passed, you should do a trust. And so I would like to welcome to the podium Attorney Anna Paiwanski.
Thank you, Nadine. Thank you, everyone, for coming. Economic Development Authority, thank you for having this, and kudos for getting us to where we are today. We've been through a lot of topics tonight, so I'm going to go fairly quickly, so brace yourself. We're going to start off with just a basic description of what is the difference between doing a will or a trust. Yes, that one. So a will is basically deciding what happens after you've passed.
Anna?
Yes.
Hold on one second. We're not seeing the PowerPoint on this side. And so, hold on one second. Hold on. We're trying to put up the presentation. Hold on one second. Awesome.
Got it?
Okay. Got it.
Okay, good.
No, we just lost it. We just lost it.
All right, well.
We have it now.
Okay. So a will is after you've passed. A trust is a bit of a different animal, because a trust, first and foremost, takes care of you during your lifetime. And I stress this because some of the questions that have been raised this evening pertain to people who are incapacitated. Your trust takes care of you until you pass. If you're unable to take care of yourself, your trust is designating who has the power and ability to take care of you. as we say, to keep you in the lifestyle to which you are accustomed. Unfortunately for all of you, you've been listening to 3 attorneys this evening tell you some horror stories, and we all have horror stories. We've been in this business for too long. And I can tell you that there are a lot of people out there, even your dearly beloved children, who after you've passed or while you're incapacitated may be thinking more about themselves than you. And the important thing is to make sure that the person or people that are taking care of you during your lifetime, when you are no longer able to do so, can manage your funds so that you are kept in the lifestyle that you have been accustomed to. Either A, not taking care of you and saving money for your beneficiaries, or simply not managing your funds well so that the funds that were planned for your lifetime get used up faster. A trust gives you that ability. A will doesn't. A will just takes care of what's left after you've passed. Now, those are the basic differences in terms of a will and a trust. I think I have a little machine here that's going to get me to the next screen. Next. Okay. So why should you have a will? One of the main reasons in the territory for why you should have a trust is to avoid probate. That's one of the main reasons in this territory. There are people in the states that they don't necessarily have to have a trust because the probate process is relatively painless and quick, and their heirs and beneficiaries can get their assets quickly. I have unfortunately had scenarios where the probate has taken so long the beneficiary passed before they got what they were supposed to get. So in the sense of avoiding the probate process, that is critical. But the other thing that the trust helps you do, my crystal ball is broken, I'm not sure if you all still have one, but you may designate somebody as a beneficiary and they may predecease you. So then what happens? A trust can give you options. A will doesn't give you as many options. So you can say, well, if this person predeceases me, then I choose for this person to get whatever that asset is. It gives you that flexibility. It also gives you the flexibility of liquidating those assets, which if you sell your home before you pass, then when it comes to a will, there's no home to probate. But you have the ability within a trust to change who the beneficiaries are. If it's a revocable trust, you have the ability to make concessions. You may have a particular person who you want to care for during their lifetime, that in addition to caring for you, you can care for the estate. The trust cares for them as well. You have a lot more flexibility in what you can do with a trust, and you can always revise it. You decide you don't like the way that particular beneficiary is behaving, or you decide you just don't like them, period. You change it. Give it to somebody else that you do like, you know. You have that flexibility. The other flexibility you have is that you don't have to give it to your children just because they're your children. If there's somebody else you want to give it to, you can do that. You can give it to your church. You can give it to whoever you want. There's nothing to argue over who you decided to give your stuff to. And it also allows you to take control, as it says. It lets you plan for the possibility that you would be incapacitated. A guardian doesn't need to be appointed because you've picked the people that you know are going to make the best decisions for you during your lifetime to take care of you, first and foremost. And if taking care of you means liquidating all of your assets so that you can be taken care of, then it has that ability to do that. Next. Okay, special advantages for Virgin Islanders. If you are a Virgin Islander or are naturalized in the Virgin Islands, either one, born or naturalized, your children inherit tax-free. Inherit tax-free, which means that if your spouse isn't, then you can put your assets, Virgin Islands assets, in your trust and non-Virgin Island assets in your spouse's trust. That way your children inherit tax-free. Or you don't give it to your spouse, they just have it during your lifetime, and then it goes to your children who inherit tax-free. That is only in the Virgin Islands. That's not assets outside of the Virgin Islands. I always recommend that aside from talking to an attorney, you talk to a CPA or an accountant, because there's tax implications for where your assets are, depending on your tax bracket, depending on this and that and the other thing. So you want to have a conversation with the CPA so that they can tell you, well, in this case, if you put that asset in your trust, it's going to be taxed at a higher bracket. Maybe it will, maybe it won't, but you want to ask an accountant that question. You don't want your heirs to find out that by doing something or not doing something, you've raised the taxes that they're going to be exposed to. So I always recommend that they have those conversations. We've had some conversations here tonight about deeds and pay on death or a transfer on death. And there may not be a tax consequence for that. There may be some other disadvantages, which we might get to if you remind me, but there's tax implications depending on who gets what. So have those conversations. Don't just have a conversation with an attorney. Not every attorney is an accountant. So don't make that assumption. Let's see if this works. Next. Okay, revocable and irrevocable. A revocable trust you can change, just as I was describing before. You can change who gets what, you can change who takes care of you, you could make all kinds of changes, add more assets, do all of those things, change beneficiaries and all of those things. An irrevocable trust is set in stone. You don't change it. Now, some people are looking at me like, why on earth would you do that? There are some tax benefits to having an irrevocable trust. Again, have a conversation with the CPA as to whether or not that is something that may be worthwhile. Next. Okay, what should I put in my trust? Everything. I tell people when I do these presentations, the last thing you want is to leave out Granny Sugar Bowl and have somebody go to probate over Granny Sugar Bowl because that's what they want and spend more money than Granny Sugar Bowl was ever worth in anybody's imagination because it wasn't there. Now, I'm not saying you have to itemize everything. You can say all of the things in this home, or you can take on the adage, a picture paints 1,000 words. Take pictures. Then once you have the pictures, you've got paintings, you've got crystal, china, whatever you've got, records, whatever it is, decide who gets it, okay? That makes it easier. And if you don't know, you may just say, well, sell it and then just divide the proceeds. But identify everything somehow. The easy things, bank accounts, property, a vehicle. The bigger things people tend to think of more. But you may have a savings bond that you got 20 years ago that you don't even remember. Think about the things that you have and think about who may want those things, but try to include everything. You don't necessarily have to itemize the sugar bowl, but you can say everything in the kitchen, divide it up, however you decide to divide it up. But it's important not to leave things out. I literally did a trust where the person who was doing the trust had a dog. And it was very important to them that their dog got taken care of. We had a picture of the dog. We had a whole financial plan for the care of the dog because this was important to them. But I say that because there are things which, like we talked about earlier, you may not necessarily think it's valuable, but it may end up becoming the most expensive thing you have in your house because it's going to cost $10,000 to probate it. So when you go in, pictures are really easy. Put your jewelry down on a table and take pictures. It's easy. Take pictures of the artwork and whatever you inherited from your parents and grandparents, just take pictures. You have no idea who's going to fight over it later. Next. Okay, what decisions, you go. What decisions do I have to make regarding the trust? Who's going to be the initial trustee? Normally it's you, but you may know that you've got some condition that's going to make you incapacitated in the near future. You may identify someone else. Who you identify as your successor trustee is critical because remember that person is taking care of you during your lifetime if you're incapacitated. Pick people that you know will do what you want, okay? It's very important. Sometimes it's not a family member. Sometimes it's your best friend because you know you can trust them to do what you want. But make sure that you pick the people that are going to carry out your wishes. Choose wisely. Who is cared for during your lifetime? It may be you. It may be a spouse. It may be both of you. It may be a child with a disability that needs special care. There may be a relative of yours that you want to care for because there's nobody else caring for them. Whoever you want to take care of, you're going to identify those people in your trust. Okay, in some cases, if you have young children, you want to make sure that they're cared for and that their schooling is paid for, etc. You're going to want to give the instructions as to what you want done for those people that are minors and need care, and what they want for regular schooling through high school, college, etc. And your spouse or loved one that you want cared for during your lifetime and during theirs. Sometimes what you do is you set it up so that even if you predecease that person, the trust still takes care of them until they pass, and then it gets distributed to the beneficiaries. Who's going to make medical decisions? This is also extremely critical. I've had situations in which people have picked someone who was going to make their medical decisions, and then when they got sick, they realized that person's going to do what they want, not what I want. And this is very important, and everybody is different. Some people want to be on life support until a cure comes along. Some people don't. Some people want, there's some family members that don't want you taken off of life support, but that's what you want. And they make the decision that they want and not you. When you make these decisions, these are critical decisions. You want to make sure that the decisions you're making, the people that you are designating to make those decisions, make your decisions, not their own. And that you can trust them enough that they will do that. Okay? So it's very important who you pick. And again, it may not be a family member. Okay. So, as I said earlier, You can designate who gets something, and then you can designate what happens if they don't survive you. Okay? And you have the ability to do that. Sometimes when I sit down with people, I tell them, I may sound like the Grim Reaper, and I kill everybody off, and then I say, okay, so after all of those people are gone, then who? And I've had situations where this has literally happened. Everybody died in a terrible accident. And then who? Because again, you're trying to avoid probate. The last thing you want is to have this person be the beneficiary. They've died. You haven't identified anybody else. So what's going to happen? It's going to go to their probate. It's not going to get resolved unless you have a backup plan. What happens if they don't survive you? Then what happens? Who gets it? And it may be a charity, but you want to close that gap so that somebody else doesn't end up in probate. Per stirpes, and does somebody else become the beneficiary? So normally what we do, if you have children and they have their own children, so you have grandchildren, you would say, okay, well, I'm going to give it to my children per stirpes, which means if they don't survive, then it goes to their children equally. Okay? That's just a term of art, but that gets you to the next level. Again, back to the previous one, if your children and your grandchildren have a terrible accident, you want to have a concession for what happens. Does it go to your other children? Does it go to someone else, a relative, an uncle, what have you? How do we make sure that everything we want in the trust gets put in the trust? You need to put it there. Now, we've talked about deeds, and those are fairly easy. You do a transfer, a deed of gift, you put the property in the name of the trust. A vehicle, you do the same thing. You transfer the vehicle from you to the name of the trust. Since 9/11, we are all impacted by all of the new banking regulations that are now in place. You can't just name your trust as a beneficiary anymore. There was a time where you could. You actually, in most banks, have to open up a trust account as opposed to naming the trust as your beneficiary. So you would close your regular account and you would open a trust account. Some banks in the Virgin Islands do not do trust accounts, others do. And then that trust account then takes care of all of your expenses, etc. But then there are other things. So you, like I said, we take pictures. If you take pictures of your jewelry and you identify who gets them, that's the equivalent of putting it into your trust. Anybody can open up your trust, look at it and say, oh, okay, that necklace, the Sagittarius one, that one goes to this grandchild. It's not a question anymore as to what your intention was. And when we talk about like business interests, things like that, you would literally transfer ownership of that business, whatever portion of it that you have, into your trust. So you no longer own that business. Now your trust owns that business. So then that doesn't have to get probated. So these are the mechanisms by which you put literally everything that you want to put, including Granny's sugar bowl, into the trust. And sometimes what I've had to tell people is you have to call your institution. If you have a CD or you have a 401k or any other kind of investment account, you literally have to contact each one and ask them, what do I need? And the other critical component these days is asking them, if I don't put the trust as the beneficiary, because it may create a tax consequence, then how many beneficiaries can I name so that you make up for the contingencies? If that one predeceases, then it goes to this one, sort of thing. There's a lot. Each of these institutions has their own form. You can't just fill out a form, you have to fill out their form. And you have to be very specific about how you write down who gets what. in some of these scenarios. I had one myself recently where I had a nonprofit that was supposed to receive a small portion of something. And when the investment person got back to me, they said, oh, well, you know, if this person predeceases, then all of it goes to the nonprofit. And I'm like, time out. No, that wasn't the plan. You have to tell me how I'm supposed to fill this piece of paper out so that they only get the portion that they're supposed to get. So you have to ask the questions and get the right paperwork so that you know that what your desire and intention is actually gets carried out. So sometimes there's a lot of background work. You've got to go ask people for forms and make sure that they get them, and they have all kinds of new confirmation systems so that you have to upload them into these portals and do all of this special stuff to accomplish your objectives. But it's critical that you do, because if you don't, you're leaving something behind that becomes a probatable issue. Okay? Bank accounts, the reason why I highlighted that again is because with the banking regulations that we have today, you have to be specific. One of the things I recommend that you ask the bank is, when I die, does the beneficiary just have to bring you a death certificate? And if that's what you are trying to accomplish, whether it's pay on death or whatever the account the banking institution uses as its process, you do not want to have that beneficiary walk into the bank and be told you have to go probate this. And I've seen it happen. So unfortunately, 5 years from now, that pay on death language may go out the window, and they may have invented something else. You have to stay on top of these institutions and make sure that your paperwork accomplishes what you want. And periodically you need to follow up and make sure that everything is in place the way you want it to be, so that your desires are actually carried out. And so it's tricky. They're not going to send you a notification and tell you our policy has changed. You now have to use this piece of paper. If it was only that easy. After you have a trust, make sure that you have a living will, a power of attorney for health care. Make your funeral wishes known in as much detail as possible. I guarantee you that the people that are going to be carrying these things out for you want to know what you wanted. I have watched more people just anguish over what would mommy have wanted. And I tell people, please, just tell them what you want. Don't leave it up to them, because it's everything else they're dealing with at the time, having to make these decisions is even harder. Spell it out as best you can. Pour over will. We were talking earlier about wills and whether you have a will if you have a trust. You absolutely have a will if you have a trust. We call it a pour over will. Basically, it says whatever I left out goes in the trust. The trust will tell them where everything goes. You could inherit something. I had this happen recently. No clue that you're the beneficiary of something. Clearly it wasn't in the trust, but now they're marching off to probate this asset. If you have a will, at least it helps to speed up the process, because it says put it in the trust. Okay? So you always have a pour over will when you do a trust, because it's possible you could leave something out. As many times as I tell people, after you've put your trust together and your trust is in place, please don't buy anything outside of the name of the trust. You've just defeated the whole purpose if you go out and buy a car in your name or buy a piece of property. And I've seen it happen. I can't tell you how many times. And then what happens? People end up in probate. They've got a perfectly good trust, but they bought something and didn't buy it in the name of the trust, and off they go to probate. Okay? It happens, trust me. Review your trust. Every 3, 5, 10 years, review it. You may have changed your mind about those loved ones. They may have already passed away. You may have decided that they don't deserve what they're getting. Or you may decide that somebody else who wasn't even born yet is now the person that you want to. It doesn't matter. Just revise. It's very easy to do an addendum, but you want to stay on top of it. You don't want to be in a situation in which all of the people that you've named as beneficiaries are all gone and you haven't updated things. Another thing that has happened, and I've seen this quite a bit lately, is lending institutions change your account numbers. Like, you may not even realize it because it's still the same lending institution and it's still an account. But they've changed the numbers because their numbering system changed. So your trust is very specific. It's got all of this information about this account number, but the account number's changed. Or they've reinvested with another institution. It's not even the same company. It's a whole different company. So all of that stuff you said about Ameriprise, it's not even Ameriprise anymore. It's now something else. You want to revise, update, make sure that everything is current. If you've sold something, what I usually tell people is the most important thing is what you buy, not necessarily what you get rid of. But when you do these amendments, if you know that things are gone, rather than having people looking for things that have already been sold, you can throw into the amendment the things you don't have. You got rid of that 30-year-old car and you got a new one. Put the new one in and just tell them so that they're not chasing all over the place looking for that car that doesn't exist anymore. Just another line item that says this car has been sold and you're replacing it with this one. Simple. Assets may change. You may decide that you want to do something else. Tax laws may change. So the implications of what you're doing may change and you may need to make some adjustments to try and avoid some taxes. And just stay on top of it. It's not something that, oh, finally, it's done, I can put it away. Please don't just put it away. Take it out, look at it, make sure that things are current. It's amazing what can happen in 3 to 5 years. It's truly amazing. And we might be finished. Next. Questions? Yes. Transfers of deeds on death. This is a very fun topic for me because I have a different perspective.
Anna, could you repeat the question? Could you repeat the question because we didn't hear?
Okay. Mike? Or just say it and I'll just repeat it.
Yeah, so if you have a transfer of deed on death, I was looking it up, like for a vehicle, and you still owe money on the vehicle, and then you were like getting to the age where you can die tomorrow. So do you have to contact the bank that you have a loan with and ask them if it's okay for you to put that transfer on?
Okay, so the question is, if you have a transfer of death on deed and you have a loan with the bank, do you have to notify the bank about the transfer? So I'm going to double this question up with respect to a mortgage on a piece of property for a trust as well. You notify the bank that you have this provision. You can send them a copy of it. It doesn't change anything. It's still going to affect that vehicle or that piece of property, but you're going to want to keep them abreast of what you're doing. And just as a caveat to that, when you transfer your vehicle to your trust, you want to let the insurance company know that you've done that so that it has the right name. You know, they're not big deals in terms of like, they're not going to tell you, no, you can't do that, but you want to make sure that the paperwork matches. I do want to say something on transfer on death. It's a great concept, but what happens if that person predeceases you? And that's the concern that I have with respect to the provision. Obviously, if everything goes as planned, your children will live longer than you will, or your grandchildren, whoever you've designated that are younger than you, but I don't have a crystal ball anymore. I don't know if they're going to be there. And I'm not 100% clear on how much you can change that transfer once you've done it. Now, we may have some options. The youngest living person identified in the trust. It's a, the word just went literally.
21.
Rule against perpetuity. 21 years after the last living beneficiary. So normally the trust will have that language in it, and then it doesn't violate the rule against perpetuities. But if you were to create a trust, let's say at 25 years old, and you live to 100, the bank doesn't have a basis to say this trust is too old because it's been around for 75 years. That just doesn't make any sense to me. But as long as it doesn't violate the rule against perpetuities, it's not an issue. You may have to move your account from that bank to another bank, but that's a different conversation.
Okay. Questions from St. Croix on trust?
If you plan to turn your business into a LLC, would you do that before it goes into a trust or after it's in the trust?
You need to make sure the trust exists. As long as the trust exists, you can, it's 6 of one and half dozen of the other. But the trust has to exist.
Question on St. Thomas?
Yeah, we have a question.
Thank you so much. One question. When it comes to, we had a lot of the attorneys here spoke about contingencies. Predeceases you, or you may not know within your network people who might be qualified to carry out these very important tasks. What are some of the tools or options that people can have where the trustees can be competent and could survive the lives of any people that might be in their lives? For example, corporate fiduciaries and things of that nature.
So, managing your trust is a very personal thing because you want it to be somebody who knows you and what you want and what, carry out your wishes. Now, what we normally do is we have contingencies in the sense that we have maybe 3 or 4 successor trustees, and we tend to pick the successors based on who's younger, so that you may be picking somebody who is, the third person might be significantly younger than you are, but somebody that you know. There aren't successor trustees that hold themselves out to do that. There may become an industry for that. I'm not 100% sure that I would be comfortable with an absolute stranger managing your interests. I think you would probably be better served by having a friend or family member, maybe it's an accountant that you work with that maybe it's an accounting firm to manage some of the financial aspects. But you really need to, I've had people literally take a year to decide who their successor trustees are going to be. It's a big responsibility. It is a thankless task. and you want to give them as much information as possible so that they're not running around looking for your assets and trying to figure out what you have. You want to give them as clear a roadmap as possible. But at this stage, I'm not aware of people who hold themselves out as successor trustees, but even if there were, I'm not 100% sure I would just jump on the bandwagon and say, yes, I'll have an absolute stranger make my decisions for me. I'll repeat, yes.
Earlier you mentioned trust bank accounts and trust brokerages. I was curious if you establish the trust and then you open the bank account with brokerage, or is the trust bank account or trust brokerage separate type of account or entity?
Okay, so the question has to do with brokerage accounts, bank accounts, and whether the account is initially a trust account or something else and then becomes a trust account, right?
Or if the trust account or trust brokerage is separate from the account opened by the trust. But you mentioned trust bank account, trust brokerage, but it seemed like it was separate from
Okay.
the trust where you would put the property in that trust.
Right, so in most, maybe not all lending institutions, if you have an account already, because of their accounting system and new legislation, a personal account has these numbers, a business account has this series of numbers, and a trust account has this series of numbers. That hasn't always been the case. 9/11 has a lot to do with some of these changes. And so there was a time where you could simply change the name on the account from your personal name to the name of the trust. Most institutions now don't do that. Most of them have their own form, and you would then fill out the forms, and the account would literally be taken from your personal account and moved to a trust account. So then it becomes a trust account. Now, if you can open a trust account. In other words, we're not talking about an account that already exists. We're talking about you creating an account. For the first time, you can open a trust account at an institution, and it'll be designated as that trust account.
But I would need to establish a trust first. That's why I tried
Absolutely.
to get. It wouldn't be me opening an account. It would be the trust opening an account.
You can't.
And that's what makes it
right.
the trust bank account or trust brokerage, correct?
Right. You
Okay,
have
that's
to
the
have a
clarity.
trust in place before you have anything in the trust. And this is also very critical just about everything. You can't transfer property to a trust that doesn't exist. That's not going to be a valid transfer. If you transfer a piece of property in 2024 to a trust, but the trust doesn't exist until 2026, forget about it. Any other questions in
Okay,
St.
I have
Croix
a-
online?
I have some questions online. One of the questions is pertaining to how to help a successor trustee in financially dealing with the trust. Can you put the money in the trust to deal with administering of the trust?
Yes, so as we were just discussing, a lot of times you end up moving your personal accounts into a trust account, so it now is a trust asset. And when you move your property into that trust account, then the successor trustee has access to those funds to pay your medical bills, to pay for your light, to keep WAPA going and get your gas bill paid and all of those good things. And so that is accomplished through the avenue of having that account in the trust already. If it's not in the trust, the only mechanism that you have is a general power of attorney. But that general power of attorney is only going to be good during your lifetime. And then when you die, so does that power of attorney. And if that asset's not in the trust, it's not in the trust. You're off to probate again.
Okay. One moment.
Open a trust for someone if you have their power of attorney?
Possibly. Is the person incapacitated?
Their health, their medical, everything is in there. And you say, well, okay, in their discussion, a trust is the best thing to do. Can you do that on their behalf?
You might, I'm hesitating because you might be able to, but if that person has capacity, your better bet is that they, as the settler, set it up. They sign the document themselves if they have the ability to do that, and they have the capacity to do that. That is the better route because they are the settler and they're not just the power of attorney. Somebody could later on, when they're not happy with what the trust says, say, oh no, that wasn't their wishes, you manipulated the situation as the power of attorney and did something that wasn't their intention. That's why I hesitate. Legally it might be something that could work, but is it foolproof? I would think that it would raise some flags.
We have some questions from Zoom.
Yes.
The first is, can a trust done by a VI husband and wife control disposition of real property in the States?
Yes. That was an easy one. You still have to transfer the property. Okay. You do not need more than one trust. Your trust can manage all assets anywhere on the planet. You just want to transfer those deeds from you to your trust and get them recorded in whatever place that is. Doesn't matter where it is. But yes.
Is having someone articulate on video what their wishes are valid? Additionally, is it recommended in lieu of a will?
You could probably have a video recording that you would have witnesses at, and probably somebody to verify their capacity, and that recording potentially could become an authenticated document, but you would need to meet all of the requirements of a will. Presumably somebody would take those recordings and draft them up and have it signed. But I mean, the concern I have is with the technology that we have, if that recording is not clear and half of it's missing or chopped up, you don't really have a complete document. That would be my concern. I would still want it signed off on, notarized, with all of the requirements of witnesses, etc.
So we have one question from St. Croix, and then we're going to ask all the attorneys to sit on the panel so we can do general questions for the next 10 minutes because we are now over the 8 o'clock hour. But we do have one last question on trust from the island of St. Croix.
Yes. What makes a trust valid? What validates a trust? And is it filed anywhere?
There's no filing requirement. What I tell people is, at least for the trusts that I've created, there's a lot of confidential information in those documents, and it's not a matter of public record. I have a different take from some of the other attorneys in terms of what you want your beneficiaries to know. I've unfortunately had experiences where people literally have tried to get the grantor to change things and write people out and put other people in and do some crazy stuff. So my take on that concept, at least as far as a trust is concerned, is if you don't know what you're getting, you're not going to try to lose something. You may be better off leaving it alone. With respect to what is required in a trust, the trust has to be drafted by the settler, And if they are the trustee, they would identify themselves as the first trustee and then identify the other people that are the successor trustees. It has to be signed, witnessed, does not have to be notarized. If you want it to be notarized, it can. It does not get recorded. I have seen some people do that, and I shake my head wondering why anybody would put all of that information on a public record.
Okay.
What I
would
recommend
like to
is that
invite all the attorneys to the table so that we can ask general questions for the next 10 minutes. We're going to have a speed round. We're moving cameras. St. Thomas needs to move their camera to the table. And we have Attorney Ballantyne and Attorney Paiwanski in St. Thomas. And I know there's some burning questions to ask questions. Make sure for those that are leaving that you fill out the estate planning conference exit survey, please. It's really important to us to make determinations as you're walking out. But here's the first question from St. Croix.
Thank you. Hi, good evening. Quick question. Is the transfer on deed, is that applicable only to Virgin Islands, or is that applicable statewide as well?
The answer is that it would. Can you hear me? Yeah.
Yes.
The answer is that it would depend on the statutes in the other states. So the TOD statute in the Virgin Islands applies to Virgin Islands real property and Virgin Islands vehicles. If you have property located in another state, it would depend on whether that state allows a TOD deed or not. So if you have property in Michigan, it would depend on what the law is in the state of Michigan.
Okay. From the island of St. Thomas.
Hello?
Any questions?
Yeah, we have a question.
Okay. Please go ahead.
Good evening. Can you hear me? Yes. Oh. Okay. I have a question for the benefit of the audience. Can you explain what a probate without administration is, and in what situations would a court more likely allow it or not?
I guess I'll start on this one. A probate without administration is an expedited probate process in where basically you don't have to file a notice to creditors. It shaves about 6 months off the probate process, but those beneficiaries or heirs that take a distribution pursuant to the final accounting have to sign off that they're subject to any creditors' claims since creditors were not notified. So it depends on whether you want to go through that process to clear up creditors' claims or take the property subject to creditors' claims.
Okay, we have a question in St. Croix.
Good evening. My question is, when is a trust required to file a tax return?
So most people, again, this is an accounting, you talk to your accountant about this. There's two options. One option is that during your lifetime, you can have the trust use your Social Security number. A lot of times I've seen accountants file the return under the individual until they die, and then upon their death, they get an EIN number for the trust, and then the trust files. I've seen scenarios where the trust during your lifetime files. I've seen scenarios where you individually file with something on your tax return that refers to the trust, and I've seen scenarios where the trust itself is filing with its own EIN number. This is an accounting CPA question as to which category you're going to fall under. But one thing that is guaranteed is after you pass, the trust has to have an EIN number and then would file a return under that EIN number.
Attorney Ballantyne, you spoke about ideas of things that we have to remember. One of the things that we hear about a lot is forgetting to take ex-spouses off of a beneficiary receipt. Could you speak a little bit about that, please?
Well, I haven't had that experience
Life
but if the person is named as the beneficiary, that person is who will get whatever it is they're named for. So it is important that you keep up to date on everything in terms of the changes, not only in terms of your assets, but changes in your own life. So if you have an ex-spouse and you want to make sure that they're off of all of your accounts, your insurance policies, your health insurance, unless you have a divorce decree or something that says they have to keep them on there, but other than that, you want to make sure that you're changed to reflect your current state of affairs.
Thank you. There's a question over here. Hold on.
Beneficiary under 18. Can you hear me? Beneficiary, if you have a child that's under the age of 18, should you make them your beneficiary? Should you list them as your beneficiary?
You can list them as a beneficiary. You mean like if you had several beneficiaries, you can list them as a beneficiary. I think the concern, you may want to have a situation where you have someone as their guardian until they reach the age of 18 or something to that effect, so that in the eventuality that you may pass before they reach 18.
Okay, good evening.
We have a question from St. Croix.
Okay, thank you. Regarding administrators, executors, when they're doing their assets and their detailed report on the debts and the balance, is there a timeline when they have to provide that information to the heirs or beneficiaries? And two, when does the executor administrator, when they share the inheritance to, like, if there's more than 1, 5 or 7, whatever, do they share what each individual receives? Or is it just per?
So once the administrator or executor is appointed by the judge as the executor or administrator of the estate, then basically they have to produce a quarterly accounting every 3 months. That quarterly accounting is submitted to the court, and it has to be copied to all heirs or beneficiaries. So pretty much it's an immediate accounting responsibility, and it's distributed to the court and to all the ultimate heirs and beneficiaries. Likewise, when the probate proceeds to a final accounting, the final accounting presents the total amount of the assets and the proposed distribution to every one of the heirs or beneficiaries. That is distributed to, that proposed distribution is sent to all the heirs or beneficiaries, and they must sign a waiver of any objection and consent to their proposed distribution in order to get the distribution signed off by the judge. If anyone does not sign the waiver and consent, then the court will conduct a evidentiary hearing, and those beneficiaries or heirs that did not sign the waiver and consent will be allowed to appear and propose or propound their objections. So that's how it goes.
Okay, we're going to take a question from St. Croix and then one from St. Thomas, and then we have people online still with questions. So, St. Thomas?
Question over here.
Hi, good evening. My question was, what's the average cost of a trust? The average cost of a trust.
Okay, that's a difficult question to ask, and what I normally tell people is if you go into an attorney's office and based on the value of your estate, they tell you how much it's going to cost, run to the exit. Having said that, most of the time what increases the cost of the trust is the amount of things that need to be transferred. If you have 2 pieces of property being transferred to the trust, it's going to obviously cost less than if you have 10 pieces of property transferred to the trust. So it is a factor of how much documentation has to be created to effectuate the transfer, but the trust itself probably ranges between $2,000 and $5,000, depending on what it is that you're putting into it. But the thing I can't stress enough is, if you go into an attorney's office and you've got a piece of property that's worth a couple $1 million and they base the price on the value of your property, that's not the mechanism that determines what it costs.
Okay, a question from St. Croix.
Tony Scott McChain, will challenge. How does it work? For instance, if somebody has like 2 or 3 kids and they have a will, and one of them are willing to challenge the will, how does that work?
Basically, the disgruntled heir or beneficiary would file a notice of will challenge with the court, and they would explain what their challenge is. They may state that their parents had been deceased at the time that this alleged will was forged. They may say that they were incapacitated mentally or physically at the time, thus it must have been forged. Or they may say that during some period of incapacity, there was undue influence by another relative, which resulted in a more favorable distribution to that heir or beneficiary. Those are the standard will contests I've seen. After the will contest is filed, there's usually an opposition from the executor supporting the validity of the current will. Oftentimes then there's an evidentiary hearing scheduled before the court, and there will be a process by which the parties are allowed to engage in discovery, issue subpoenas, try to determine the validity of each side's allegations. Then witnesses and evidence will be presented at an evidentiary hearing, and the judge will ultimately make a ruling on whether they find the propounded will to be valid or whether they accept the will challenge and believe that the will challenge was supported and that the will presented was invalid. That's, again, going to be a lengthy process. You're probably looking, one, at the motion practice, then you're looking at an evidentiary hearing, then you're looking at a discovery period to gather the evidence, and then a presentation to the court at a rather lengthy evidentiary hearing, and then a period of time for the court to digest all the evidence and make a ruling based on the facts and the law.
Thank you. We have another question, and then we'll go back to St. Thomas. Hold on.
Hi, good evening. I have a question. I was involved in an accident at one point, and the person who owned the vehicle was coming after my assets. Can I ask why he was so eager?
Cross.
Nadine, you can hear me?
We can now hear, but we couldn't hear before.
So you want a question on St. Thomas?
Oh, you have a question on St. Thomas? We just ask a question on St. Croix, and then we'll go to St. Thomas. Actually, a question online. At what age should you consider having a will or a trust? At what age? If we can't hear you, we start with St. Thomas. Can we hear St. Thomas? Let me see, please. Second block, St. Thomas.
Hello, St. Thomas.
Hello? Yes, we have questions.
Okay, so wait, we have a question online. Ask the question again.
At what age should someone start a will or a trust?
If you have something of value, you could start one at any age. If you're a teenage millionaire, I would suggest you have something.
Okay, we're going to go to St. Thomas because there's a question on St. Thomas and then come back to St. Croix, to the online.